of the trade. We're going to talk about what it means to enforce the governing documents. What are your options as board members when it comes to enforcing your documents? And I have some kind of real world experience, some war stories of things that you can maybe use to try to avoid problems, and maybe some strategies you can use, and things that you do need to be concerned about and worried about. So to start off here, and let me just say that I know we're going to be monitoring the chat throughout the presentation. If any of you have questions, I know it's a little difficult in Zoom. I wish we were all in person, but I think it's still possible through Zoom. If you do have a question, I don't mind being interrupted. You can take yourself off mute if you want to, or just put your question in the chat box and I'll try to get to it as we see them. And I do find that questions do benefit everyone and make the class better. So don't hesitate to ask a question. I don't think there's any dumb questions. And I think will be multiple people on here that probably are thinking the same thing that you are. So please do that, and don't hesitate to do that throughout this presentation. So, all right, I want to put this picture up here. And I kind of chuckle every time I see this picture, because this, hopefully none of you ever come across something like this in your community. Hopefully you can all see that. But, let's say you're driving down the road, and I'm sure this doesn't go up overnight, right? I mean, you're going to see this thing being built, but you have something like this that goes up in your community. And I'm going to bet that most of your documents are going to prohibit something like this in one of your owner's yards, unless I guess the board signed off on it and approved it. Chances are this thing went up and there was no approval process that was requested or done. So, what can we do? What can an association do when something like this happens in your community? And I have a story I'll share later where I did actually have a case years ago that involved something similar to this, and I'll tell you what we did. But when we talk about enforcing your documents, I think we have to kind of first go to that 30,000-foot view of what is the purpose of enforcement. Why do we even have to have a class like this tonight? As board members, why do you have that responsibility to enforce what's in those documents? Well, I think the one way to look at it is we live in HOAs, we manage, we work with HOAs, and they serve a purpose. There's a certain order to things in these communities. You have a standard that has been established and what is to be expected, and that's dictated by the documents, and those need to be enforced. If you're going to maintain that standard, maintain that order of things, then you have to do what the documents tell you to do. And as soon as you stop doing that, that door starts to open, and you can start to lose control of your community and what was anticipated when it was developed. There is something to be said about preserving property value. There are studies out there that show the increased value of homes in HOAs compared to homes that aren't in HOAs. I know a lot of people like to hate on associations, and they certainly don't have a lot of fans out there, but there is value in it. And as far as your property values are concerned. And one other thing to mention is that we talk about this, we'll stress this tonight, the importance of enforcing your documents, because you do run the risk of litigation for not enforcing your documents. And there's exposure to maybe not you personally as board members, but certainly to your community and your association. Let me just check here. All right, so I see that there's questions about the board, this presentation being recorded, and I can certainly make these slides available to anyone who wants to review them later if you have to leave a little early. So, and there's one other question there, and we'll maybe try to address that a little bit later with a specific question. So when we're looking at kind of this overall picture of why are we enforcing the documents, we have to also look at the language of your CC&Rs. And I don't know how many, if we were in person, I'd ask for a raise of hands. How many of you have read your CC&Rs as members of the board? How many of you have read your bylaws? How many know what your specific policies of your community say? You know, if you're on the board, if you've signed this up for this thankless job that you're participating in, I would hope that you have taken the time to try to review and understand what your documents say. Now, you may not understand everything that's in there. You may line up 4 or 5 attorneys in this industry to ask for their interpretation of what a particular provision means, and then you may get 4 or 5 different answers. Sometimes things are not written very clearly, and I understand that, but there's this idea that you need to make an effort, I think, as a board member, to try to understand what your documents are, because if you're going to be tasked with enforcing them, you need to know what they say and what the requirements are for the owners and for board members. Now, one of the things that you'll see in your documents is, I refer to it as the mays versus the shalls. Many of you probably know what I'm talking about. For those of you who don't, these are words that you will see throughout your documents. When it's talking about the different restrictions, different requirements, it will say something to the effect of an owner shall do this and this and this, or shall not do this and this and this. The board shall do something, or that's the mandatory requirement. Or there may be a discretionary option of it may, if it so chooses. It's very important to understand the difference between those words, because that dictates whether or not you have the obligation to perform, or whether you have this discretion that if you choose as a board member that this is in the best interest of our community, we have that option. If we desire to do it, then you can do it. The discretion like this really comes up in architectural issues. When you're faced with an architectural decision, you might have this discretion on whether or not you approve something, but you need to understand that difference. And one thing that highlights the importance of that word is this case here. I don't have the citation, but if you go onto a search engine, Google, whatever, type in Johnson versus the Point Community Association, it will be one of the first things that pops up. It'll be a case, and if you like to read case law, I would recommend that you read this one. This case was decided, I think, 22 years ago, but it's still relevant. It's still good case law, and it speaks to this issue of an association having to enforce particular restrictions and the ramifications of choosing not to do what the documents say. In this particular case, Johnson was a neighbor to another family with the last name of Boyd, the Boyds. The Boyds were attempting to, and I may not get all these facts completely right, but the Boyds, I know, were attempting to make changes to their property. I believe they'd constructed a trellis structure. They had rewired and run some wiring that was exposed. There was a paint color issue, and the Johnsons live behind them, so they see this going on all the time, and they don't think that it should be going on, so they complain to the association, asking why is it that they're able to build this. And the board kind of inquires a little further, realizes that the architectural process hasn't been followed properly. They force the Boyds to submit for approval. Some things are approved. They come to an agreement on the paint color. I think they came to an agreement on the trellis issue, but the CC&Rs had a requirement for electrical wiring that all such wiring, it said it shall be concealed. It can't be exposed, whether you paint it or not, it can't be exposed. Well, the board, in working with the Boyds, thought, you know what, we're going to let that one slide. Where we think it's okay, as long as they paint it the same color as the house, we think it's okay. Well, the Johnsons didn't like that because they could still see the wires, and they sued over it. And it actually went to the Court of Appeals. But what's interesting is the Johnsons prevailed in this case. The association was in the wrong because the documents required that if any owner wants to install this particular item, this wiring, they have to conceal it. There was no discretion there. So the board was at fault for allowing this to occur and choosing not to enforce this particular restriction in the documents. So they as it says here, the association could not waive the process set forth in the documents. And so the Johnsons prevailed on this particular case. It's just one example of what could happen This is kind of that worst case scenario that you actually get a lawsuit filed and it goes to the Court of Appeals, where I'm sure a lot of money was spent. But it highlights the importance of knowing what your documents say and knowing when you have some discretion to enforce and when you're required to kind of lay down the law and tell owners what they have to do. You know, a lot of homeowners, the excuse we hear all the time in this, I'm sure every management company and every law firm that does this type of work, and the board probably hears it too. You get a lot of homeowners that try to say that they didn't know there were CC&Rs. They didn't know that they had to comply with the CC&Rs. They didn't know there was an architectural process. And so a lot of times there's an educational, a learning curve, I guess, that has to take place where, you know, owners aren't going to be happy about it, but they have to understand that when you buy into a community with deed restrictions like CC&Rs, whether you sign a document or not, you are bound by what's in those documents. You have to abide by them. But as this case highlights, the association has to abide by it as well. Okay. So with that, some of the methods of enforcement that I want to go over tonight, I'm just going to put them up on the screen. This is not an exclusive list. It is the most common remedies that an association has when it comes to enforcement. You know, someone builds that clubhouse, or someone just doesn't take care of their landscaping. You know, what options do the association have? Now, some of these options are governed by state law. If you live in a planned community or a condominium, there's going to be a body of law that governs your community. And so you need to try to be familiar with that. There's also some of these are governed by your CC&Rs. And so the options that you have are going to depend on what's in your documents. And so then again, kind of the importance of understanding, you know, what your documents say. I'm just looking at a comment here. I'll just read so the question says, what should HOA boards do when a homeowner does not file architectural application and the change does not meet the standards, such as a front door change? I'm going to just kind of hold that question. I think that question will be answered as we go through this particular process. I don't want to get ahead of myself, but that's a good example, and I think we will highlight that of what options you have when that takes place. So just hold on to that, and if I forget to address that, then send me another chat and we'll talk about it. All right. So before we get into the specifics of each one of these options, I do want to mention that whenever you're faced with an issue like this architectural thing where someone, you know, failed to either follow what was approved or didn't get approval before making the change, you need to ask yourself a couple questions. And I think there's 3 questions on here. I'm going to put them up one at a time here, but these, I think any board that is faced with this should ask yourself these 3 questions when deciding what you should do. And you can do this in conjunction with your attorney, your manager, you know, work together on this. But I think you need to look at what authority do you have under the governing documents? What are your options? We just mentioned that before, that some of these options are governed by your CC&Rs. So if you may not have these options, but what is our authority? What do the documents say with this particular issue? Is the option that we're going to choose, whether it be fines or self-help or a lawsuit, is it the reasonable option under the circumstances? If you see that someone has failed to remove some weeds in their front yard, for example, it's probably not reasonable to rush to the courthouse and file a lawsuit because someone forgot to pull some weeds after a rainstorm. It's probably better suited to maybe go the route of sending some notices, and if you have to impose fines, maybe you start there. But if someone builds a gigantic clubhouse in the back of their house, sending them some letters with some fines probably isn't going to do anything, and it probably would be more reasonable that you got to go to court pretty quickly to try to get them to stop or get them to remove what they've done. So you got to look at what's reasonable under the circumstances. And then, is that method going to achieve your desired results? And again, that kind of goes to the reasonableness analysis. If you have a clubhouse like that was built, you know, assessing fines of $50 or $100, whatever your fine structure is, probably isn't going to do anything. they're probably going to ignore it, and they're probably just going to continue to keep what they have, or or do something else, or if they're in the process of doing it, they may not stop. But if it's just a kind of a minor issue like fines or a trash can, you're probably going to get a pretty good response if you just start at the lower end of things and issue a fine. So there's a question here: what if your governing documents are silent on an issue? Well, if your question, if what you're asking me is if they're silent on a particular action that's being taken by a homeowner, I don't know if that's what you're asking me, but the association can only enforce what's in its documents. So there's a clarification, they're old documents. So that's a good question. I mean, many of you may have documents from 1960s or 1970s that may not have contemplated certain activities. So there's two things to look at. If you're, like I said, if your documents do not mention something, you can only enforce what are in your documents. But your documents may also allow you to create rules, which we're going to talk about in a little bit. There might be a way to address certain issues that are going on in your community that may not be specifically addressed in your CC&Rs. So it's just going to depend on the way your documents are written, and there's certain language that I would look for in your CC&Rs that might do that. And the nice thing about rules, which is another question that's just popped up, is that the board, in almost every case I've seen, the board has the sole authority to create, to change, to adopt new rules. As long as they're doing it the right way, a board in a board meeting can adopt these new rules, and the owners have to abide by it. They don't have to take it out to a vote of the owners to change rules. So if your documents are silent, though, and you want to try to address something, the only other option that you may have would be to amend your CC&Rs and to try to add that restriction. But I don't want to go too far down the rabbit hole with CC&R amendments, but there was a case last year from the Supreme Court that has made amending your CC&Rs much more difficult. And in some cases, it's probably impossible. So it requires, if you're trying to make a change to add new restrictions that were never there before, there's a good argument that you're going to have 100% approval from your owners to do that. So I'm going to leave it at that on the amendment issue. It is, as someone says here, it is an expensive process to try to do that. Changing the CC&Rs is not something that the board can do. That has to, well, I actually have seen some CC&Rs that might allow a board to do that, but they're very rare in almost every case. And there's actually state law that requires an owner vote. So if a prior board is deviated from the CC&Rs, you're probably going to have to try to get that ship steered back in the right direction. Now, one of the things that I think I mentioned it later, but I'll just mention it now just in case, is that when we're talking about enforcing your documents, there may come a situation where if you continue to fail to enforce a particular provision of your CC&Rs and you allow these things to continue to happen, there are legal arguments out there that would suggest that you might have abandoned that certain provision of your CC&Rs to where you can no longer enforce it. So that's why it's important to stay consistent in your enforcement, because you don't want to lose control of what your community is and what's allowed. So there's a question here: do we need 100% approval to change the bylaws? Probably not. Those are governed by a little bit different procedure. Bylaws are usually require a vote of the owners, but not always. There are bylaws that allow the board to just change it. But if it requires a vote of the owners, there's just a percentage it's usually around 2/3 of the owners would have to approve a bylaw change. So, all right. So back to these slides here. Ask yourself these questions when you're looking at a particular issue to enforce, and it should help you in knowing what option is best for you. Another thing I'll say here is, when we're talking about what are we enforcing, we've talked a little bit about this, but in addition to the CC&Rs, again, the CC&Rs, there's usually a section in your CC&Rs. It's usually in Articles 4, 5, 6, somewhere in the middle, And a lot of times it's titled use restrictions. Those are going to be the restrictions on property. Those are going to be what the owners are allowed to do and are not allowed to do. But there's other things that you try to enforce. You're going to enforce the collection of assessments and possibly fines. There are other issues that might be mentioned in other sections of your CC&Rs that you may have to enforce. There may be that separate architectural section that talks about the process to follow for architectural approval that you're going to need to enforce. So you do really need to be familiar with your CC&Rs and what they say. But the other thing that you have to be aware of are the laws that change. Every year, the individuals that get themselves elected to the state house and the state senate and work down at the legislative offices, they'll get, and I serve on a legislative action committee, and so we are very involved in monitoring these bills as they come through. And every year, without fail, what will happen is that one homeowner in one community out in the outskirts of somewhere will complain about an issue, and they'll bend the ear of their local representative. The local representative will look at that and say, well, I don't want that person to be mad at me. I want that person to vote for me next time. So I'm going to make an issue of this, and I'm going to write a bill and act as if this is of statewide importance. And they'll attempt to adopt and introduce these bills that want to change HOA laws. And there's a group of legislators out there that are not fans of HOAs, and every year they try to impose new restrictions on HOAs. But why that's important is because, part of your job as members of the board is to make sure, and this is why you hire managers and hire attorneys to help you stay on the right track, but you got to be aware of what the law says and what the law allows you to do especially when it comes to enforcement. Last year, for example, there was a change to multiple statutes that speak directly to enforcement. There was a change in the political sign statutes. There was a change in the flag statutes that talk about which flags you're allowed to enforce against and which ones you can't touch. There was a new change, and if you lived in a single family community, planned community, there's restrictions now on artificial grass and whether or not you can tell a homeowner that they can or cannot have artificial grass. There's also been case law on the enforcement process and imposing fines. So, attending events like this, most of the firms offer educational seminars, and your management company, we work a lot with management companies to help them stay on top of these things. You got to be aware of this when you're faced with a particular issue, because that will dictate what you can or can't do. Let me just, a bunch of things have popped up in the chat. Let me just make sure I'm not missing anything here. So I got a question here on fines and whether or not a homeowner can ignore fines. Hold that question. I will talk about that in a little bit. CC&Rs are badly outdated. We need 100% approval to get newly drafted and updated ones in place. Possibly. There are changes you can make to your CC&Rs that are not going to require the 100% approval. It's just going to depend on what you want to do when you change. You may be able to rely on the percentage requirement that's in your documents. It's likely 2/3 or 75% or maybe a simple majority. But again, the Supreme Court case spoke to specific types of changes and whether or not owners had noticed that those changes might occur. And so that's why I say if you're trying to make changes to introduce new restrictions, new requirements, that's where it's going to trigger that requirement. Can individual board members be personally sued for not enforcing the CC&Rs? The answer to that question is yes, they can be. Board members are sued. No, I'm not going to say all the time, but I have handled many cases where board members are named as defendants. But let me tell you this, I don't want any of you to go home tonight and resign from the board because of what I just said. In almost every situation that I've seen, you have protection from 2 or 3 different sources. One, if you look at your articles of incorporation or your bylaws, or if you even look at the Nonprofit Corporation Act, board members are to be indemnified by their association. That means that an association will pay for your legal costs, that'll pay for any judgment entered against you. You are not going to have personal exposure for any sort of liability that may come your way. There are some exceptions to that. If you do some intentional wrongdoing, or some reckless negligence that damages the association, you may not have that protection. But it does require a pretty serious act by a board member to just disregard the law, disregard the documents, disregard legal opinions, and just do whatever they want to do. If so there may be a situation where you wouldn't have that protection, but for the most part, your insurance policy, hopefully you have directors and officers coverage in your policies. With your insurance policy and with the law, all of you, whoever's on this call right now that's serving on the board, almost every situation you're going to be protected. Just make sure that you're not doing the intentional stuff that is going to damage, and it damages the community. Sometimes there's kind of a fine line, but just as long as you're trying your best, you're listening to your experts, you're going to be fine, even if you are named in a lawsuit. So, all right, I have a lot of questions here. So I'm going to do this here on these changes. And some of depending on what law firm your association uses, a lot of the law firms have statute books that they're willing to send out and provide to their board members. I know we do, but I'm going to give you some references here. I don't want to take the time to go into all the specifics of the change in the law because we just don't have the time for that tonight. But I'm going to give you some references here. So if you live in a planned community, so single family homes, maybe townhomes, you're going to want to look at, I'm going to say ARS, which is Arizona Revised Statutes. You just can search that, but it's section 33-1808. So 33-1808. Okay, that's the statute that was revised that covers pretty much everything that's on this screen. If you live in a condominium, I'm going to make sure I give you the right number because I mix these up sometimes. It is 33-1261 is the statute if you live in a condominium. Now, the artificial grass doesn't apply to you if you're in a condominium. It would just be the signs and the flags. But there were some changes made to those statutes, and there's more on the horizon. The bills that are currently being introduced right now that are going through are going to make more changes. So come the summertime, I think every firm, every organization will have a class that goes over the changes in the law, and I'm sure we could schedule another one like this with Vision where I can tell you about the changes in the law for this year, but you just got to be aware of that. So I'm going to move on here. I know there's some questions here. I'll try to make sure I think I'll address most of these in our discussion here. So I do have one more slide here on just enforcement in general. When we're talking about what are we enforcing? There was a question, I think, about rules. I gotta do a little discussion on rules because as an attorney, having done this as long as I have, one of the most common problems that I see in communities are rules run amok. Associations who get very aggressive with their rulemaking and exceed their scope of authority when creating rules. So I would assume that most of you have rules in place. You might have board resolutions, you might have policies, maybe an enforcement policy, a collection policy, record retention. There's all kinds of policies, but you might have specific rules, architectural rules, or just rules for behavior in the community. What you have to understand about rules is that rules are the basis, the ability to create rules is a function of authority granted to you by the CC&Rs. Now, for those of you who live in planned communities, you have your common area that the association owns. There is an inherent authority to create rules that govern the common area. But if you want to try to create rules that govern someone's property, then that has to be something that originates out of the CC&Rs. And what I mean by that is the CC&Rs will have a section somewhere in there that gives the association the authority to grant, to change, to amend, to enact rules and regulations. And then it will do one of two things. It will say that the association has the authority to create rules, and then it will say that govern the common property, period. Or it will say create rules that govern the property with a capital P. When you see property with a capital P, you want to go up to your definition section. Hopefully you have one. And you'll look in that section, and a capital P property is usually referring to the entire community, which includes houses, units, common areas, common property. It's everything. So if you have that language, then the rules the rules you create would be allowed to govern everything in the community. Behavior of owners and residents, activity on the property itself. But if your rules are limited to the common property only, you don't have the authority to create rules that govern someone's lot or that govern someone's unit. And that's where I see the problem come in. I've had clients where they give me their documents, they hire us, and I look at their rules, and the rules are 30 pages long. And then I go look in their CC&Rs, and they're limited to rules that affect the common property only. And there's rules in there about basketball hoops, about colors of paint, and certain things that are directly related to the property itself. And you can't have that. That's you don't have the authority to have those rules. So you have to be aware of that. Make sure you have the right authority. The other big issue with rules is you cannot contradict anything that is in the CC&Rs or the bylaws or any other governing document. The rules have to be consistent. So you can't create a new rule that contradicts what's in the CC&Rs, because that, if you think about it, you're really, in a sense, amending the CC&Rs through a new rule. Well, you didn't get the vote of the owners to do that because the board creates the rules. So you have to be careful with your rules. Make sure that you have the authority, and make sure it doesn't contradict your CC&Rs. Now, a question I get quite often is, what if our CC&Rs are silent on a particular issue? Well, creating a rule for that issue doesn't contradict anything in the CC&Rs. In my opinion, there's nothing to contradict. But you still have to be careful in your construction of the rules and what they say, and what you're asking the owners to do. So kind of the advice I would give you is that, not really advice, the suggestion would be, if you are going to change your rules, I would have your manager, or probably your attorney, if you have one, take a quick look at what you're doing, just to make sure that it's dotted all the I's, crossed all the T's, because you don't want to get in that situation where you're a year or 2 years down the road trying to enforce invalid rules and regulations. I got some more questions here. Do associations have D&O? Well, associations, so the question's about D&O insurance. It's directors and officers liability coverage. You have multiple policies that you can get. Directors and officers policies is one that you absolutely should have, but it's not an automatic thing. You need to ask for it. So whether or not your association has it, I don't know. That's a question you're going to ask management. You're going to have to talk to your insurance adjuster to make sure that policy is included. Let me see here. So there's a question about assessments. Different size condos have different HOA assessments. Do the CC&Rs have to be amended in order to make the change if you want them to be the same? Yeah, that's just going to depend on the exact language of what it sounds like. It probably would have to be amended to change that. And then there's a question about submitting personal information when filing a complaint. We're going to talk about some of the issues of filing a complaint. And I don't know whether or not that's valid with that specific question. But anyway, let me get back to what I'm saying here. So and with these questions, if I fail to answer your question, I'm going to give you my email address. Feel free to shoot me an email. I can try to answer it offline. I don't want to take up too much time and get sidetracked, but oops, did the wrong thing here. I have a reference here to fair housing, and I don't want to get into the weeds in fair housing because that could be a whole nother class we could do. But when you're enforcing your documents, we have the mays and the shalls. Whenever an issue comes up, there needs to be just kind of an awareness that there is a set of laws out there, the fair housing laws, that have become a lot more recognized and prevalent in HOAs in Arizona and across the country. People attempting to use the fair housing laws to their advantage. Now, sometimes there's legitimate cases, but it is unfortunately a system that's a little bit abused. But they use that to their advantage to try to get around certain restrictions. So when you're going to enforce something in your documents, you have to be aware that you may have to allow certain things to happen because the fair housing laws require you to. There are certain people that fall into protected classes. So one of the most common ones would be someone with a disability, and disabilities can be a whole lot of things. But that's just something to be aware of, that when you're looking at a violation, these homeowners may come to you and say, hey, I've got this, and this condition. I need this particular issue to be granted because of my disability. You may have to go through that analysis and consider that when enforcing. There's one caveat here. It's not a caveat, but it's an addition to the fair housing laws that came up. I think it's been 5 or 6 years now. Hostile environment harassment. This is an additional protection that the Housing and Urban Development Department created. Essentially what this means is that if the association is aware of a hostile environment taking place in your community. So for example, you have one homeowner who's harassing another homeowner, and that homeowner falls within some sort of protected class. Like some of the protected classes under fair housing would be race, gender, national origin, familial status, they have children, or disability are the main ones. If someone's being harassed and they fall within one of those categories, the federal law and state law, it's mainly federal law, actually puts a requirement on the association. You have to step in and do something. You have to try to address and stop this hostile harassment. And if you don't, you're going to be in violation of the fair housing laws. Now, there's a lot of times where owners fight with each other, and association usually takes the position, well, that's an owner-to-owner dispute. And for the most part, that is a valid decision the board can make. This is for the owners to sort it out. There's nothing for us to do as an association. But depending on what's going on, now you're not going to see this very often, but I actually have seen a couple instances where minorities have been harassed by individuals in the community, and we as an association had to send. Now, the law doesn't say we have to stop the activity. We just have to make an effort to do that. So we sent them a cease and desist letter. This has to stop, and it did. But you have to document that. You have to show that you've made an effort to try to get this behavior to stop. That will protect the community. So just be aware of that most of the time owner-to-owner disputes are left to the owners. But if there's some harassment going on that involves someone that's in a protected class, the association is now going to be obligated to do something to try to address what's going on. So anyway, now there's one other case here I wanted to talk about. We use this word reasonable. It's a fun word. I can't give you a great definition for it. I usually say that it's the person in the man or the woman in the black robe that makes the decision as to what's reasonable. But your options when you're enforcing, they have to be reasonable. In this case here, this is another case you can look up and read. This is about the same time period as that previous case we talked about. But what's interesting about this case is this custom home community, this Ahwatukee Custom Estates, they had a situation where a homeowner bought a lot and was attempting to make changes and to build their home. And they had some grading issues that weren't really addressed by the association. They had some issues with the home that weren't really addressed, and they started to construct fences and a pool and their property. And then the association tried to kick it into gear and try to address it down the road. And the court looked at that and said, well, look, on its face, they did fail to come to the association. They failed to get approval for what they did. But the association was seeking what's called an injunction, a permanent injunction, asking the court to force them to rip it out and start over. And the court looked at that and said, well, while it's a violation of the CC&Rs, we agree, but we're not going to force them to do anything because the association waited too long. And I can't remember the number of years that went by. I think it was 5 years or something before they tried to take action, but they let some things slide. They didn't address certain things. And when they tried to go to court to address it, the court said you've waited too long, and we're not going to give you the relief that you're seeking. So the reason I bring up that case is that we have to be diligent when we're enforcing our documents. And I've mentioned this already a couple of times, kind of this loss of control, that if you wait too long, you're going to put your community in a corner, kind of box it in as to what your remedies are and what's available. And you may not be able to do anything about something that's happened if you wait too long. One last thing I will say, and this kind of goes to those questions that we asked as to whether or not you should take particular action, is that depending on what you decide to do as a community, there is going to be an expense involved, and sometimes that expense is a lot higher than other times. But what does the association have the ability to recover the money that it spends, whether that's with an attorney or not? There are going to be expenses, and you need to look at your documents and determine whether or not we have the ability to recover what's been spent, and those assessments that you're using to pursue this remedy. Going back to that disability real quick, someone asked, can a homeowner claim a disability to avoid paying a fee? Like a new pool key claiming can't afford to disability. Possibly. The thing with fair housing, and I don't want to say too much because we'll get distracted here, but the request that's being made has to be directly related to the disability that they're suffering. So there has to be what's called a nexus. It's a legal connection between the two, and it has to be a necessary thing. So, someone who's blind has a seeing eye dog, community that doesn't allow animals. Well, they're going to there's a connection there. They need that dog. So connecting someone with a disability to having to pay a fee, that might be a tougher one for them to connect the dots. So it's just going to depend on what the request is, what the accommodation is they're requesting, and whether or not they're connected. I know it's probably not the best option or answer for what you're asking, but a lot of that, it is a case-by-case analysis when it comes to fair housing. All right, and I kept teasing you on these options here, and we're finally here to the specific options. So I'm going to go through these, and I know I don't know how much time we've got tonight, but I'll try to get through these so that you have an idea of what, and it's not going to be an in-depth analysis on all these, because like a lot of these you could spend a lot of time on, and so I don't want to spend a ton of time on each one, but enough to help you understand what it's all about. So the most common option, what I think should be the first option for almost every violation that comes up, is going to be the imposition and assessment of fines. Now, state law allows condominiums or planned communities to impose a fine, regardless of what your documents say. You have the right to assess a fine for violations. But with that right to assess fines comes some requirements and some conditions. And the law does say, as it says here on the screen, you have to provide the owners with notice and an opportunity to be heard before you impose a fine. And the fine has to be reasonable. So there's our good friend reasonable again. So what's a reasonable fine? Well, as most attorneys will tell you, it depends. It depends on what the violation is. It depends on the extent of the violation. And there's no black and white answer here on what's a reasonable fine. You just kind of know it when you see it, and you hope that the judge agrees if it gets that far. So we'll talk a little bit more about that in a minute, but your fines have to be reasonable. The notice and opportunity to be heard is covered through your violation letters. Now, those of you, if you're all working with Vision, I know their system, I know their process. They have good violation letters. They have a good process in place that they'll send that stuff out. But you have to have these notices that are going out to your owners before you impose these fines. And the notice has to have certain information on it. It has to provide specific information that's called for in the statute. And then once you send that notice out, it's going to tell them what they have to do to contest the notice. That's one of the requirements. Once you've done that, that's their opportunity to be heard. You can impose a fine. You've given them that notice. They have this opportunity to contest it. you don't have to wait for them to contest it before you issue a fine. So I hope that most of your communities or all of your communities have some sort of a violation enforcement policy in place that will govern this. And I think we talk about that on the next slide. But you just got to understand that before you impose any fine, you got to know that you've got to give notice and an opportunity to be heard, and then it's got to be a reasonable fine. Now, as far as the letters go, let's talk a little bit about a little more specific on that. Most communities I represent have a system in place where they start with a courtesy notice. That's what they call it. You know, it's just a friendly reminder that CC&Rs say what they say, rules say what they say. We've observed a particular condition on your property that's not in compliance, and we'd ask you to please correct that. There's no fine attached to it. It's just please correct it in 15 days or whatever the time period is. You don't have to have a courtesy notice. There's nothing in the law that requires a courtesy notice. But I think they're good. I think it's I think it kind of maintains a little bit of order in the community. I think they're a good thing to use. Like I said before, there is language that has to be in your violation notices. The one that is absolutely required is this idea of providing the owner with an opportunity to contest it and what they have to do if they want to contest it. That has to be in every notice. Now there are some other there's some other content that may need to be there, like the provision of the documents that's in violation, when the violation was observed, who observed the violation. Some of that stuff, though, doesn't have to be provided with the first notice. But understand the way the statute reads that if you provide someone with a violation notice, the owner who gets it has 21 days to contest whatever's in that notice. So they can send a response to the association within 21 days and contest it. If they do that, now the association's required to provide that information I just mentioned, unless it was provided in the first letter. So some communities I've seen will just throw it all out there in the first letter. You know, when the violation happened, who saw it, what provision of the documents was violated, and how do you contest it. Some don't. Some will limit that because unless someone sends a letter in response, you don't have to provide that. So it is one thing to I think there was a question before about filing complaints. People who file complaints about activity in the community, you have the right to do that. You just have to know that if you file a complaint, there might be a situation that comes up where your name has to be disclosed to the person in violation. Under the law, we may have to disclose that information. So you need to know that. Now, whether or not your community requires you to provide a picture, and I mean, that's going to be governed by your documents. It might be a situation where the association's trying to confirm that you are actually a resident or actually an owner in the community. I don't know. It's hard to answer that one without knowing more. But with this whole thing of violation notices, there is a requirement out there that you have to have an enforcement policy in place with what's called a schedule of fines. And hopefully you all have that. The enforcement policy is going to lay out when your notices are going to be sent, how many notices you're going to send, and then accompanying that policy is this schedule of fines that will lay out what are the fines going to be, how much for the first notice, second notice, third notice. I've drafted enforcement policies that actually have a chart that will differentiate fines based on the violation. So if it's a violation for maybe landscaping issues, you're going to have one set of fines. But if it's a violation for short-term rentals, you're going to have a fine structure that's different and probably a lot higher than a weed violation. That's how I do it for my clients, and it doesn't have to be that way. But you do have to have a stated policy that lays out the fines. If you don't, none of your fines are going to be reasonable if they're challenged. An owner will be able to go to court, and a court will overturn and disregard any fines if there wasn't a fine policy in place. So check your documents tonight. Make sure you have a fine policy. I know that Vision has a policy that they help the communities with. So I'm going to guess most of you probably have one. But just be aware of that. There is that requirement of having a fine policy and a schedule of fines. I'm just looking at the chat box again. So the first question is, going back to the violation notices, do they have to be mailed out or can they be sent by email? That's actually a good question. Let me just look real quick. I thought it said in the statute that it has to be mailed. It's a good question. It actually just says a written notice that's received. So it looks like maybe the notice you send out to your owners doesn't necessarily have to be mailed. But if they're going to contest the notice, the statute does require them to send that certified mail back to you. There is that requirement in the statute that owners have to do it certified mail. Question about whether if the management company is following an enforcement policy. So the thing you got to remember with this enforcement policy is, I kind of mentioned this already, that if you're not following the policy, then it becomes a lot easier for members, for owners to challenge any attempt to enforce your documents. You know, I mentioned before that your notice has to provide the manner in which they can contest the violation. The reason that is so important, because the statute specifically says, if you don't include that in your violation notice, you are not allowed to take any other action for enforcement. So if your notice doesn't have that, and then you hire us to file a lawsuit, well, any attorney's fee, I mean, you're just going to be out of luck with this lawsuit if they can show the court, look, they never gave us an opportunity to contest the violation. They should have never filed the lawsuit. Now, I can tell you that if it came across my desk, we're going to be asking for copies of those violation notices if we didn't send one ourselves, to make sure they were given that opportunity. But you're not allowed to, and so any fees you incur, you're not allowed to try to collect any charges if you haven't followed the proper procedure for your notices. And so that's why it's so important. If you have a policy in place, you need to follow it. If you try to impose fines that exceed what's in your policy, they're not going to be reasonable, and someone could easily challenge that and prevail. One other thing that might be in your policy is when do you get an attorney involved? When do you ask an attorney to send a letter on the association's behalf? And it doesn't have, you don't necessarily have to go through 4, 5, 6 notices before you get the attorney. Your policy, a lot of times the policy will kind of have an alternate provision that says, you know, you reserve the right at any time to send this to the attorney if you need to. Because sometimes there's, like I mentioned before, there might be issues that you can't wait. You can't spend the time in the 2 or 3 months it might take to run through the notice provisions to give someone notice when you need to get this addressed quickly. So the notice requirement is there because of the fine issue. So if what we're focusing on is fines, then you got to go through this notice provision. If they've ignored a couple of your notices, you probably want to have your attorney send a letter. And a lot of times the attorney will, you know, it is just because they get a letter with, you know, 3 or 4 names on it that are a law firm, and they will sometimes take that more seriously than, unfortunately, from a letter from a board or a letter from a manager. So again, it depends on the situation, but you'll need to kind of make that assessment. Do we want to ramp this up and have the attorney send in a letter? Good question here. There's a question about if you do have communities, or I'm sorry, if you have homes in your community that are rented out. There's a question about the actions of a tenant and who's responsible. You need to remember that the owner is always on the hook for whatever their tenant did. So if we're talking about violations of the CC&Rs, if an owner isn't complying, the violation notice is going to the homeowner if the tenant's not complying. And so that makes it difficult sometimes, because then it puts the owner in this position of trying to get their tenant to comply while also kind of fending off the association and their notices. But associations are responsible, owners are responsible for the actions of their tenant when it comes to enforcement. That's a good question. Now this this case down here, this Turtle Rock v. Fisher, this was a case from I think 4 years ago now, where an association got really aggressive with their fines. They were doing daily fines. The total fines, I think, got up to, I want to say $15,000, something like that, for this lady's violations. It went to court, and the court looked at it and said, yep, there's violations here, but your fines are outrageous. the lower court lowered the fines, but still awarded some fines. It went to the Court of Appeals. The Court of Appeals looked at it and said, we agree with the lower court, but we also don't agree with one thing that the lower court did. We don't think they should have awarded any fines. And it's because this Turtle Rock community did not have an established fine policy that was introduced as evidence, setting forth the fines. And so the court in their decision said, any fines that are imposed without a schedule of fines are per se unreasonable. So there's not even a discussion. It doesn't matter if it's $1 or $100, they're unreasonable and cannot be levied against the homeowner. So the importance from that case is the need for a schedule of fines in your community. So make sure you have one of those. Now, fines may not work. I'm sure you have, well, I shouldn't say I'm sure, but I would imagine some of your communities, you've had a situation where a homeowner just thumbs their nose at your notices. You put as many fines as you want. This reminds me, there was a question before. I'm gonna tell you the dirty little secret about fines. Okay, fines can only be collected a couple of ways. If you have an account in your community where you have some owner who doesn't care, has $1,000 in fines, the only way you're going to collect those fines is if you sue him or her for those fines personally. You file a lawsuit and your damages are the fines that were incurred, or they voluntarily pay them. Okay, fines are not part of your lien. So if you have a lien for assessments and collection costs and late fees, and the property goes to title because they're trying to sell the property, you can't stick the fines on the title payoff and get paid through closing. Okay, they're not part of your statutory lien. Now, there might be a creative way to include those, but the statute is very clear that fines are not part of the lien. Now, the fines don't transfer to the next homeowner either. So when the next homeowner comes along, if there were $1,000 in fines on the last homeowner's account, they're gone. Okay, they're still the responsibility of the previous homeowner. You could still sue the previous homeowner to try to recover those fines, but the new homeowner doesn't have any fines on their account. They start over. Now, there might be a situation where there's a violation on the property still that wasn't corrected. And that's why it's so important to include in any sort of resale and disclosure statement when someone goes to sell their property. If there's unresolved violations, those have to be noted in the documents so that violation transfers to the new homeowner, but the fines don't. So there are homeowners out there that understand how this works, and they don't care if you put fines on their account because they know you're probably not going to sue them for it and they're never going to pay it. So what does it matter? And there's some truth to that. So just be aware that fines can be an effective measure to bring compliance, but there are ways to avoid fines. So the next option is what we call self-help. This is an option that's 100% governed by your CC&Rs. And what I mean by self-help is there's going to be a provision in your CC&Rs if you have it. It's usually in the enforcement section towards the end. It might be buried in the maintenance provisions in your documents. But it essentially says that in the event an owner fails to comply with the CC&Rs, the association is given the right to go onto that owner's property and bring the property into compliance and possibly charge that cost back to the homeowner. There's different variations of this language, but that's essentially what it says in most cases. There are some advantages to that. You know, you don't have to go to court. You don't have to worry about fines. You can just get it done. The property gets fixed. But I think any sort of advantage is greatly outweighed by the risks and the disadvantages of this option. And I'm just going to jump right to the risks because most homeowners will not understand this. They will not accept that this is actually a thing. They will call the police. They will try to cite your people for trespassing. Just so you got to be careful with this option if you have it. For my clients, the advice is usually this. If the home is vacant and possibly owned by a bank, then you could consider self-help. But then even that self-help is probably limited to landscaping issues. I had a manager call me a couple years ago to say that they were going to exercise their rights to self-help to go into the backyard of someone's home and tear down a clubhouse that they didn't have the authority to build. And I pleaded with them, please do not do that. That is not going to end well for you. Thankfully, they listened to me and they didn't. We went a different route. but there's a time and a place for self-help, and I think it's pretty rare when you should use this. Just because you can do it doesn't mean you should. There's also procedural requirements. It usually requires a separate notice and a separate time frame than what might be in your enforcement policy. And there's sometimes a procedure, a resolution that the board has to pass to authorize self-help. So just be careful with that option if you do have it, but just know that your documents may allow it. The other option that might be in your documents, again, this is driven by your documents, is the ability to suspend someone's rights. Now, that could be the right to vote. That could be the right to use a pool or a clubhouse. Again, it's all driven by your CC&Rs. And so you're going to have to know where that language is, and you have to see what that language says. And what's the authority, what's the notice requirements, how long does the suspension last? Sometimes it's limited. Sometimes it's only for 60 days. So you just got to know that option might be there. Now, telling someone that their right to vote is going to be suspended is probably not going to bring compliance, because most people just don't care. But if you tell someone they can't use the pool, or more importantly, that their tenant can't use the pool because their property is in violation, that's probably going to get their attention. So this might be a good option in certain circumstances where a fine may not do anything. Taking away their rights in the community might be something to consider doing. But again, it's just, it depends on what your documents say, and you need to know what it says. For the questions that were just asked about what your rules need to match city ordinances and insurance deductibles, I would, if you, maybe we talk about that offline. If you want to send me an email with that, we can address it. I think that gets a little bit away from what we're trying to talk about here, but they're good questions. Just maybe shoot me an email with that. The other option, if suspension of rights isn't something you can do, you do have this option in some cases to record what's called a notice of violation. You can actually record a document with the county recorder's office that puts the world on notice that there's a property in your community that has a violation on it. You need to look at your documents. You need to see if you have the authority to do this. You also need to understand that there are risks that come with this. If you're wrong, if the information you provide is inaccurate, now you've created potentially a wrongful lien against that person's property. Again, it's an argument, and there are statutory penalties for doing that. If they correct the violation and you forget to record a release of that notice of violation, that's going to be a problem for you. So these can be a good tool to use. It puts the world on notice, and especially title companies on notice that there's a violation that's not resolved. But there are parameters you have to follow and stay in doing that, and you want to make sure you don't run afoul of that. The question again about self-help, I'll just reiterate. Self-help, the suspension of rights, potentially the notice of violation, all of that has to be governed by your documents. If your CC&Rs are silent on any of these remedies we're talking about, with the exception of fines or a court remedy, you can't do it. You don't have the authority to do those remedies if your CC&Rs are silent. So I'll just kind of reiterate that point. Now, what I will refer to as kind of the last ditch effort, in the event your fines aren't working, you don't have the right to do self-help, you don't have the right to suspend anything other than maybe voting rights, or there's a situation like that first slide I showed you where a clubhouse went up and you need to take immediate action. There are legal remedies out there with courts that allow you to do that. What I've put up on the screen are different remedies that you can seek. One is the first two are kind of the same thing. A preliminary injunction or temporary restraining order is going to court and asking for immediate relief to get someone to stop doing what they're doing. You want a court order to get them to stop while you work things out. That requires a very specific set of facts. The other option is a permanent injunction. That's very similar, where you're asking the court to get them to stop doing what they're doing, but it's not as immediate. Or you're getting the court to order them to do something. Maybe you need to order them, you have to submit for approval, or you have to do X, Y, and Z. That would be what's called an injunction. and the court can issue those and order homeowners to come into compliance. These types of claims are breach of contracts claims. I mean, the CC&Rs are a contract between the association and the homeowners, and they're bound. And owners, like I said before, owners are bound by the documents. So that's typically what the claims are when we do this, when we file these lawsuits. I will say these lawsuits are time consuming and they can be very expensive. So that's why I say it's a last ditch effort. You need to try to do anything you can to get an owner to come into compliance. And then if nothing else is working, then you can consider or should consider a lawsuit. Now I'm going to share with you an example. This is a case I had, it's probably 7 or 8 years ago now. It was a pretty extreme example of where we had to get to court pretty quickly. So I have a couple pictures from the case. I'm not going to tell you the name of it, but I'll show you the pictures here. So on this particular day, the community manager was driving through the community, and they were doing what most management companies will do. A tour of the community every 14 days is kind of a standard practice. I've seen management contracts that are a little different, but they were doing the 14-day tour. And she drives by and she sees this going on in the community. And you can see there, I mean, this isn't just some cheap looking fence. I mean, you've got cement footings, you got this wrought iron kind of fencing, the steel fencing that's going up. I'll go back to this slide here. You can kind of see, and I wish I had a pointer, but back behind the trailer is the front door to the house. And you can see the cement wall to the right of that separates the front from the backyard. This is what ended up happening. This is kind of the final product here of what was changed. You see all the fencing that went in. He actually removed the cement wall and put this wood slats up. He did it on both sides. And what's not shown in this picture is there was a sliding gate that went across the driveway. He could open and close. So the association made us aware of this. Within a couple of days, we had a cease and desist letter that was sent to the homeowners. You know, they didn't waste their time with a violation notice. It went straight to the attorney. We sent a letter asking this person to stop. Now, this person was familiar with the process, had served as the board president years prior. He knew what was going on. We sent him a letter to stop at this stage here when it was still the post in the ground. He ignored us, and within, I think it was maybe a month later, we were here. The fence was done. So we went to court and we filed we filed for an injunction telling the court, hey, this guy didn't have the authority to do any of this. He didn't ask for approval. Even if he had asked for approval, we would have said no, because there are no other houses in the community that have anything close to this. He needs to be ordered to remove it. Well, as the bad luck would have it for the community, this owner responded with an attorney and started alleging fair housing. He claimed that as a Vietnam War veteran, he suffered from PTSD, and that was his disability. And because of that disability, he should be allowed to have this fencing because it created a safe space for him. It created this environment where he felt protected. And that was a direct result of having PTSD. Now, on its face, you think that sounds ridiculous, but there were some legitimate arguments to that we had to sort through. Now, one of the things where his case sort of fell apart a little bit is this guy had lived in the community for 20 years. And the source of his PTSD was his service in the war back in the 70s. So nothing had changed between 2000, I think, I don't know what it was, 2000 when he bought the house, and 2000, whatever it was when he built the fence. And so if you remember before, I said there has to be that connection. There has to be this necessity to have this accommodation. Nothing changed. It wasn't that something triggered this where all of a sudden he needed this fence. He's lived in this house for 15 years without a fence and nothing's changed. And that's ultimately how we prevailed on this case. But another thing he said is that he was going around the community, touring the community, looking for bad guys. And he sent us this picture during the litigation. And those are 2 bulletproof vests. I think that's an AR-15, knives, guns. And he said he would put all this body armor on, and he would go around the community looking for trouble and trying to stop bad things from happening. And once he had the fence in place, he no longer had to do this. Well, we couldn't settle this case. We ended up going to a trial. I think it was a 2-day trial. And we ultimately prevailed because he could not make that connection for his fair housing, and it was a clear violation of the documents. So we ended up spending a lot of money on this because he hired an attorney, and the court cut our attorney's fees pretty substantially. So we prevailed, but we kind of lost as well because we weren't able to recover all the attorney's fees. He did remove the fence. The court ordered him to, and he tore it down. So that was one of the extreme enforcement cases I've had. Hopefully you don't ever have to go through something like that. Let me just see here. There's a couple more chats that popped up. Okay, so I've got a couple more slides here. I know we're kind of running up on the time here, but I want to make sure that I mention a couple more things. Whenever you do enforcement, especially if you file a lawsuit, and this, I've kind of tried to highlight this throughout, there are some defenses that are out there that might kind of torpedo your case. One is called selective enforcement. And what I mean by that is you're not consistent in your enforcement. You have an obligation as board members to treat every owner consistently, reasonably, and fairly, essentially is what it means. And you have to be consistent. If you're going to enforce your documents, you need to enforce it against everyone. Now, there might be situations where you decide not to, and there's ways around this, but the bottom line is you need to try to be consistent in your enforcement. And you have to be careful on when things are approved, when things are disapproved, and how you convey that to the homeowners so they don't get it, so there's no misunderstanding. This waiver, abandonment, latches, that's all the stuff we've talked about already, where the association has failed to take action and has allowed it to get away from them to the point where maybe you can no longer enforce a particular provision. Along with these defenses, there are counterclaims that they might bring. You know, if you haven't followed the proper procedure and you file a lawsuit, they may respond with their own lawsuit back against you saying you breached the contract. You're in breach of your duty as a board member for doing X, Y, and Z. You're in breach of fair housing, like we've talked about. So there are arguments they can make back against the association. So that's why it's so important to understand your documents, be consistent in your enforcement, and follow your documents when you're doing it. Just some common mistakes that are made. You depending on your community, you may actually need to consider budgeting for enforcement. I mean, if it's a big enough issue, you may need to think about that and plan ahead, because it can get expensive to have to enforce. When you're enforcing, you need to make sure you have the evidence and the documents to support what you're doing. Just relying on one particular board member's testimony is probably not going to be enough. We need pictures. We need evidence to support our claims that we're bringing. Unfortunately, I do see situations where board members, it becomes a matter of principle, that they just, there's no wiggle room. You have to do this, and it's a principle of the matter. And I'll tell you that as soon as you start litigating on the principle of the matter, in a way you've already lost, and it's going to cloud your judgment throughout. So you need to be careful about the principle of the matter. As board members, one takeaway tonight is when you're doing these things, when you're enforcing your documents, in the back of your mind, you always have to tell yourself and remind yourself, and even ask yourself, is what we are doing in the best interest of our community? It's not the best interest of what I think is best. Is this going to be the best decision for our community? And if there's a question there, then you should step back and reevaluate. And common mistakes too, award of attorney's fees. Hopefully your attorney will look at that issue and make sure that you can recover fees, but there might be a situation where fees aren't awarded to you, or maybe you didn't read your documents carefully enough. So it's very important, if you have an attorney that's helping you, please make sure you tell your attorney everything on these issues. The worst thing for an attorney is we get into a complaint, we get into an argument with the owner's attorney, and all of a sudden something jumps out that should have been told to us 3 or 4 months ago and wasn't, and it changes everything. So share with them your emails, have a frank discussion with your attorney, and make sure they know everything. You know, they know all the circumstances. You know, are there other owners in the community that where you've dealt with them and maybe done it a little differently? Because homeowners will go find that. They'll use that as examples of being inconsistent in your enforcement, if there's similar violations. So just be aware of that. Tell your attorney everything that's going on in your community, if and when you get an attorney involved. And then lastly here, just the conflict resolution. You know, there are options out there. Unfortunately, a lot of these disputes come up because there's a lack of education. Homeowners don't understand what their rights and obligations are, and a lot of times boards don't either. And so I would invite every one of you that are board members to try to educate yourself as much as you can on what your community is about, what you're allowed to do, what your documents say. And then, you know, hopefully there's a line of communication with your homeowners. You know, you hate to see communities where it's kind of the board behind the Iron Curtain that doesn't communicate with the community and just kind of does things on their own. That's where the distrust starts to develop. The questions, you know, you start getting the disgruntled homeowners are wondering, what in the world is the board doing? You know, we don't know anything. They're not holding meetings. They're not discussing anything with us. And that's where the questions start to develop and the distrust. So communicate with your community and your homeowners. And there are services out there for mediation. You don't have to run off to court. I should have mentioned that earlier, but there's ways you can try to mediate these differences. But I'll look at these questions here real quickly. I think that was my last slide. But let me just look real quickly here. There's a question: what remedy does a board and management? What's a remedy when the board or management company does not comply with the documents? I'm not sure I want to get into that issue for the class tonight. I'm focusing more on the board. I mean, we've kind of talked about it essentially, that the board may have obligations to do certain things. And while the board may have remedies against a homeowner for not complying, the same thing could be true on the flip side. If the board's not complying, then homeowners may have claims to try to get the homeowners or the board members to comply. There's actually a dispute process with the Department of Real Estate you may be aware of, where when there's a dispute between boards or between associations and owners, it's an expedited process that you can try to resolve those types of disputes with the Department of Real Estate. What if a homeowner does not comply with the architectural committee board approval? They submitted and approved a certain color and pay, and they went a totally different color. That's a great question. If you come across that, you realize, hey, you know what? They didn't do what we approved. That's where you have to have this discussion. You need to try to get them to redo what they did, or come up with some sort of an arrangement that would be considered compliance. And unfortunately, when those things happen, those things do tend to end up in court quite often, because both sides are kind of in their corners of we approved this, well, we wanted to do this, and it's hard to resolve. And sometimes homeowners realize, oops, but they don't want to spend the money to fix it. And so unfortunately, a lot of those end up going to court to get a judge to basically mediate the situation and make a decision. So what I will say about that example, though, is if you do see someone who is making a change that you approved and they're doing something that wasn't part of the approval, you need to act quickly. Don't sit on your hands on that. Get out in front of it as quickly as you can, because the longer you wait, like I mentioned before, the doors might start closing in what you can do to get them to change what they did. So let's see here. All right, well, I think that's, and again, if I didn't answer one of your questions, I'm going to put up the slide here that has my information. There's my email address, my phone number. Any questions you have. Now, I got to give a kind of a little bit of a kind of an attorney disclaimer. I may not be able to answer your question directly, because sometimes these questions do require a review of your documents. So sometimes my response will be, well, you need to talk to your attorney about that, because they need to look at your documents. It's hard to answer some specific questions in your particular community. But happy to try to answer your questions if I didn't answer them tonight. So just one last takeaway, I think, for tonight before we go. You know, you as board members, you have this obligation that's out there, and part of that obligation, unfortunately, is having to enforce your documents. And it's hard to sometimes separate relationships between your homeowners, and you want to try to keep the peace, but there is a reason these documents are in place, and you are the body that has been tasked with enforcing those documents. And so you have to remember that you're doing this for the community, what's in the best interest of our community, and what do we need to do to maintain that order, to maintain that aesthetic, that standard that we expect for our particular community. and hopefully you can educate your homeowners in doing that, and hopefully you can find resolutions to your disputes without having to ever call me, without having to go to court. And so I wish you luck on that, and I hope you've learned something tonight and can take away something. But I appreciate you showing up tonight, and I hope you have a good rest of your evening.